Good morning and welcome to the second argument of the morning session for Tuesday on the March 2022 Kansas Court of Appeals oral arguments. My name is Ann Isherwood and I will be presiding over the hearings today, but I would like to take a few moments to introduce the other members of our panel, including Judge Henry Green, who's been with our court since 1993 and enjoys status as the longest serving judge on our court, and Judge David Bruns, who's been with us since 2011. In preparation for today's argument, we have thoroughly reviewed everything that has been filed by the parties, as well as the corresponding record of this case and a memorandum that has been provided to us. That being said, not everyone tuning in is on the same footing. So I have respectfully requested that appellant's counsel provide us with a brief factual overview so that everyone who is either tuning into the live stream or the archived argument kind of understands how it is we got to be where we are. This case is scheduled for 15 minutes per side, and I will be keeping track of that time as well as rebuttal time, so the parties don't need to worry about that. And with that, I would like to call our next case, which is number 123495 from Wyandotte County, Dave Jennings and Emily McLeod versus Elizabeth Shoak. If the parties could please announce their appearances.
Your Honor, may it please the court, Joseph Booth appears on behalf of Dave Jennings and Emily McLeod, the appellants, and I wish to reserve 5 minutes for rebuttal.
That time is granted.
And my name is Julie Gibson, and I'm here representing the appellee Elizabeth Shauck.
All right. And with that, you may begin.
Did you want me to give a short introduction?
Yes, please.
Okay. I was asked by the court to provide a short introduction, and I'll try to do that in a fairly level-handed way. This is a litigation over the ownership and control of a prized show animal and family pet by the name of Oscar. Oscar is a Cane Corso and enjoys a lineage of progenitors that have also been involved in the show industry. Both parties are involved in the healthcare industry and care for pets. The matter was tried in front of the Honorable William Mahoney, a well-known judge of great respect in our state. And our concerns now have to do with relationship of the various types of contracts that have been expressed in the arguments between the parties. Is that a fair recitation, Your Honor?
It is. Thank you very much. You may proceed with your argument.
Thank you. There's an overlay that happens within these within Court of Appeals arguments that isn't as necessarily interesting to everybody else, but crucial for us, and that has to do with the record and the documents that are surrounding various long-term relationships. In this case, we have the first issue relating to the idea of how this case laid out and was tried. In the early days of COVID, things were disrupted. This matter was set for trial on a preliminary injunction. That was delayed for some period of time, and then 3 days were heard for the trial on the preliminary injunction. But what never happened was there was never a transition in which the court would and the parties were on notice of whether or not they were going to try the entire case or just deal with the preliminary 3 questions that one has within a preliminary injunction. And that's that Betsy would have had a substantial likelihood of eventually prevailing on the case, a reasonable probability of suffering irreparable injury, and that there's no other remedy at law, and that the threat of suffering the injury outweighs the damage of the proposed injunction. And finally, that the impact of issuing the injunction would not be adverse to the public interest. Those are different criteria than the enforcement of a contract. And so, yes.
Mr. Booth, if I could just interrupt you for a moment. So my understanding from the record is that this trial took place over a course of 3 days, and that extensive testimony was presented. And that at no point during those 3 days was an express pronouncement uttered from the court or an agreement made between the parties that it was taking on a different tone and shifting from, possibly based on the evidence presented, that this was no longer limited to the preliminary injunction inquiry, but we were now shifting over to a pure ownership inquiry. Is that your
Right.
position?
Correct. The record is completely devoid of that. With the first appearance of any hint of that being with the journal entry itself, possibly you could argue that the bench note that occurred on November 25th also indicated something similar in that it issues its memorandum decision, but that's simply something that was contemporaneous with issuing the decision. The appellees have pointed out the bench note of November 19th, which also is after all the litigation was over. Parties excused in court talked briefly with counsel off the record, giving them until the 24th to work out an agreement. Otherwise, it's going to issue a decision. There's nothing in that even hints that it's going to issue a decision on the final. All other briefing and the entire structure of this dialogue dealt with the idea that it was referred to as Betsy, as we did in the briefing, but the defendant's motion for the preliminary injunction. They went first. They put on their burden. All the briefing related to that. As a matter of fact, it's also preliminary that even after the first full day of hearing, you have a response from Dave and Emily's side that talks about the preliminary injunction, and there's never any hint in the record. There isn't any closing statement by the courts indicating that it was even considering it in the last page of the transcript. Does that answer your question, Your Honor?
It does. Thank you.
Mr. Booth, let me make sure that I do understand this. And so the preliminary injunction that was heard, and we'll refer to them by first names as you've done, was filed by Betsy. Is that correct?
Yes, Your Honor.
And she had the burden of proof to prove those things necessary that you articulated for a preliminary injunction.
Correct. And that it was the gravamen of what she presented.
And at no point did your clients present their evidence in support of their claim on which they would have had the burden of proof?
I would hesitate to say at no point. That's broader than I would be comfortable with, Your Honor, because in order to deal with the fundamental question of the injunction, they had to argue that there was no enforceable contract with the Statute of Frauds. They had to argue that their position as far as what the contractual posture was and the ownership of the dog, because we're working on what I would term a prima facie evidence of whether or not there's a contract claim. So they had to go to that point at that level in order to defend against the preliminary injunction, because if you don't have a relationship, a property ownership dialogue, you don't have a preliminary injunction. So you have to defend that portion.
Well, I reckon, but that's defend. You just use the term defend, which is a little different than when you are the plaintiff and you have the burden of proof to prove these things.
Right.
I mean, they didn't have to come forward with the same type of evidence to defend that they would to prove beyond a preponderance of the evidence.
Absolutely. And if you look at the weight and measure of how many witnesses, the amount of time taken, et cetera, you can see that that Betsy accepted that burden of going forward as someone with carrying that load and needing to persuade in order to get a preliminary injunction passed. And in response, Dave and Emily are then responding with a far more pinpointed, focused set of arguments about whether or not that initial threshold could even be met.
Mr. Booth, given that this was a 3-day hearing, there was a fair amount of evidence presented to the district court, be it through filings or exhibits or testimonial evidence. So is it, I assume, your position that despite the evidence that was presented, there was not significant evidence to make a firm determination regarding ownership? And if that is in fact your position, how were your clients prejudiced by that? What evidence should the court have heard from Dave and Emily to make that decision?
There are always decisions made in how you want to proceed in these steps. And as I understand it, Your Honor, you dealt significantly with criminal law. In the earlier hearings, the idea of how much you lay out as in defense of something is very different than what you go forth on the full press for the full trial. It's strategically where you lay things. It is my understanding that there's a large body of evidence that would speak to the costs of care for Oscar, the relationship, the schedule of how much time Oscar spent, all sorts of things along those lines that would have been absolutely key. The strategy of trial counsel was to focus primarily on the statute of frauds issue, and then to defend, which is a threshold question of whether or not which we can get to in a moment, but whether or not there is even an enforceable contract for these long-term things, such as showing Oscar over the several years. And then to defend those steps on a preliminary injunction level. So it'd be a completely different case to put on with the full burden to show full ownership. But what this would have done, had it played in Dave and Emily's favor at the time, was that the court could have found that the statute of frauds applied, and it would have been game over before getting into the more transactional kind of relationship that comprise other pieces of this argument. We're often looking in contract law about the difference between the relational contracts, the long-term interplay between people and how their course of conduct, I guess would be another way to say it, and then the transaction. The argument of a transaction in a contract law is a point in time. It is what was traded for what, and that was precisely what they put forth in this first step on a preliminary matter. Does that answer your question?
It does. Thank you.
The statute of frauds, I think, is another very important element here. There's been a lot of dialogue over whether or not partial performance or full performance and the very nature of the statute of frauds. But the first thing that I think is terribly important to point out is that this was a very intimate relationship between family members. Oscar was treated completely differently from any of the other dogs that Betsy had and the interrelationship. But Oscar was treated very similarly to how his sibling Grayson was treated, in that Grayson was given to them as a gift, and then there's a period then there's this transaction that occurs in October. Betsy's faced with either giving the dog away neutered to the people out of town, or asking them if they would take Oscar to be with his sibling, and in exchange for not neutering Oscar so that he could possibly be used for other things later. What's remarkable about that is all of the other transactions that were occurring about the same time, Betsy was careful to have contracts. She's a sophisticated party in this relationship, so she created long-term contracts. Here we have no written contract. So it's reasonable to presume that Betsy had no expectation that things would go out past a one-year contractual relationship in which she had rights. But if she wanted to secure those rights, she was well aware, as were basically every one of her witnesses, including her even her own coworker, Eric Duncan, who did transactions with her, worked with her every day. There was a high trust level there too, but there was no contract. So we have the absence of a contract, and then an expectation over about 2 years past this consummation of whatever that contract was, and whether those terms are going to be enforceable.
Counsel, is it your client's position that there is no contract whatsoever, or that there's an oral contract?
The difference between a gift and a contract is somewhat difficult to discern, with the exception of the idea of consideration. You can give a gift without any consideration. So if there was, our position.
Well, mutual promises could be consideration. If I'm just asking, what's your client's position? Or is their position that this was an oral contract, or is it their position there was no agreement between the parties?
There was an agreement between the parties, and it is an oral contract. It is, will you take Oscar? I will give you Oscar if you promise not to neuter him.
Okay, and so how does the statute of frauds come into play? Is this the UCC contract?
Interesting. Dogs and pets are covered under the UCC. and would have been that transaction. That was not argued at any point by either party all the way through to right.
So you're talking about then the common law statute of frauds, what I'm calling common law statute.
33-10,
which I suppose is statutory, but you're outside of Article 2 of the UCC.
correct. The transaction was not a commercial transaction. And also
But it wasn't the sale of goods.
right.
It was the sale of goods, or was it just a gift?
It was a gift transaction. If you want to call it a conditional gift, I will give you this dog if you promise not to neuter it.
Okay.
And so I think that's fair. I do believe that the trial counsel's position relying on 33-106 has merit. And it has merit in the way this story plays out, because the fundamental consideration under common law is you just can't leave people to their common shared memory for things that truncate out over the years. And there is no way that you can have this story under especially Betsy's version of the story play out under a year. Oscar was just months old when the transaction took place. You wouldn't know whether he was going to be a viable show dog. You may or may not know whether or not he would be viable for breeding purposes. But if you give somebody the dog and under these circumstances that's a close friend, you ask him not to neuter him, then you can find out later. But that's going to take over a year. And then her theory that it would somehow—
Well, conceivably, it could take less than a year. I mean, unfortunately, dogs can die. I mean, poor Oscar could have gotten hit by the proverbial bus that my mother always warned me about in less than a year. So conceivably, this could have been less than a year, could it not?
No. You really can't get to this idea that Betsy's trying to proffer, that you're going to have this viable show career and have a dog go from 5 months old to 17 months old. That would involve an incredible set of opportunities that would be faster than what the show circuit has. It would be faster than what the maturation of the dog could be. It would be faster than what the training would allow. This is a long-term project. The testimony was somewhere around 1 or 2 to 3 years of show time before the dog retires. And then there's this component that Betsy's position has been that David Emily would function as a retirement home or later in life placement. But in order to but what that basically says is what I consider one of the fundamental errors in the decision, and that is that Oscar's Betsy's dog. You have this transaction where under any circumstances, Oscar is owned by Dave and Emily, at least to some extent, like the bundle of sticks analogy that I used.
Well, let's get to that. The co-ownership to me is the key in this whole case. Are the American Kennel Club documents in the record?
Yes.
Were they introduced at this preliminary hearing or preliminary injunction hearing?
Yes. The first one, what's interesting about the AKC is when Grayson was registered, she was registered almost immediately. And then there was a transition where the registration was moved from Emily and her deceased husband to Dave and Emily, or I'm sorry, Betsy and her deceased husband to Dave and Emily. In volume 1, page 107, we have the registration. That registration occurs just days before Oscar's first showing on New Year's 2018. And that registration shows that Elizabeth and David are the shared owners. What that means, because I'm going to anticipate your next.
When you say Elizabeth, do you mean Betsy for Betsy. What we've been referring to as Betsy? Okay.
Betsy, yes.
And she submitted that application?
That is what the record shows. And
is the application in the record, or is only what the AKC documents that they produced from her application?
Only the documents they produced from the application. I'm looking at an image right now, and it says at the top, "Congratulations for registering." It's from the AKC.
So that's a type of document that could be presented at trial, would be the application for those AKC documents, and to see who submitted that and who signed it.
Correct. I'm not aware of that being in the record at all.
And that's not in the record as far as I know.
It certainly isn't in the record on appeal. I don't know whether it was any. The exhibits for the trial that were used at trial, only portions of them were requested to be reserved as part of the record on appeal.
And just so it's clear, you were not counsel at the trial court level.
No, I was not.
Mr. Booth, you are into your rebuttal time, which you are certainly welcome to go ahead and do and waive that rebuttal time, or you can pause your argument here and maintain that time.
I will pause and maintain.
All right, thank you very much. Ms. Gibson.
Your honors, may it please the court. I want to address something right up front. I think it's important to remember that Judge Mahoney, after hearing the 3 days of testimony, ruled that Betsy's version of the oral agreement was what was credible and not Dave and Emily's version of the oral agreement. All of Dave and Emily's arguments through trial and now on appeal keep referring back to and insist that this oral agreement that they made is the controlling agreement. And that's just not the case. They have not on appeal challenged the sufficiency of the evidence that of that finding. They've only made some limited legal conclusion or legal arguments saying that it's not enforceable under the statute of frauds or this due process argument they've made. So I think
Ms.
that's,
Gibson,
I'm sorry, yes.
How do we even get to the point of ownership? How did we get to the point where we went from a preliminary injunction, which all parties were in agreement on, to this issue of ownership? And how does that not prejudice Dave and Emily's ability to really provide a good solid foundation for the court to make that determination?
Well, the ownership issue is driven by which oral agreement controls.
But that's not what was before the court.
That was what was before the court. And one of the elements of a preliminary injunction is who is if you're likely to succeed on your underlying claims. But that's not really. It is inaccurate to say that the proceeding was limited to the preliminary injunction.
How is that an inaccurate?
The parties all understood that were there. And with all due respect to Mr. Booth, he was not at the trial. He wasn't in the proceedings.
Where is that in the record?
Okay, it's a couple different places, Your Honor. So in the trial briefs that were filed by the parties, even Dave and Emily's trial brief at the very end says the ownership issue is at issue and it controls all of the claims, not just the preliminary injunction result. So
well,
they are
that's part of the underlying preliminary injunction, but that's not the primary issue that was before the court.
Yes, and then on the first day of trial, the judge notes that this is what we're hearing. We're hearing in his bench note, we're hearing the injunctive proceedings and the quiet title proceedings.
And that was communicated to the parties?
It's on the bench note. I mean,
well, the bench note's done after the fact, at least when I was on the trial court bench. I mean, or I'm writing it at the time I'm on the bench. That's why they call it a bench note. Was that ever articulated to the parties?
It was, Your Honor. And at the end of, and you'll see, and this is what we argued in the brief, at the end of the proceedings, the judge asked for an off-record discussion among the attorneys. We participated in that. He asked the lawyers, is there any additional evidence on any of the claims?
But that was off the record. How is that before us when it's off the record?
Well, Your Honor, it is, it's noted in the court after having that exchange and the parties reporting to the court that they had no additional evidence and the court telling the parties that he was going to issue a final decision on all of the claims. In his memorandum decision, he says very distinctly, no new evidence will be forthcoming. He is finding in his memorandum decision precisely what he was advised in this off-the-record discussion.
But that's after the fact of an off-the-record discussion.
It is after the fact, but Mr. Ong, Dave and Emily's trial counsel, agreed that he had no further evidence and that the judge could proceed with a final decision in the case.
How would you know that as a practical matter? If I go in as an attorney and I'm defending against a preliminary injunction where the other side has the burden, how do I know? As we all know, that's true. Anybody that's tried cases, we don't know how the evidence is going to come in. We don't know what additional evidence might come up, what might come through. I mean, here aren't we talking about two completely different type of hearings? One in which the other side has the burden, and it's only a standard of likelihood, versus flipping it around on the actual claim where the plaintiffs have the burden and they have to prove by a preponderance of the evidence that is correct. It seems to me that if they were going to do this, and I don't doubt, I'm not questioning your word about it, but we're a court of record. We have to rely on what's in the record. Seems like if they were going to do this, this needed to be a written stipulation signed by the parties or introduced on the record by the attorneys at the hearing, saying that this is also to serve as the trial on the merits in which the plaintiffs have the burden.
Well, Your Honor, I think if Mr. Ong represented as trial counsel for Dave and Emily that to Judge Mahoney that he was not going to produce any more, he was not going to put on any more evidence on any of the claims, and he agreed with Judge Mahoney's statement that he was going to issue a final decision and agreed with that procedure. If he didn't think that was the case, and if he thought he had more evidence to put on the other claims, or he thought this was only limited to a preliminary injunction, he would have raised his hand and objected at that point, or he would have filed a motion for reconsideration and pointed that out to Judge Mahoney after the decision was entered. But he did none of those things. So
but they did appeal.
They did appeal and with new trial counsel, but that was not an issue that was ever a problem for Mr. Ong. And I think it's
well,
notable.
We're not here to consider whether it's a problem for a particular attorney or to judge a particular attorney's performance. We're here to look at the record. How will it prejudice your client if we just send this back and do it the right way?
Well, Your Honor, we've already had 3 days of trial, and we've put on 12 witnesses on every issue in the case. From industry experts to various contracts, that this guardian placement is a really standard kind of agreement in the industry. We've put on evidence from each of the parties as to what their respective positions are on the overall agreement. And it would just, and it's time for these parties to.
It would be an inconvenience, but you could stipulate and do it the right way. You could actually enter a stipulation saying some of this evidence has already been presented, or deposition testimony, or testimony that's already in the can, that we're going to use that in this trial. And if it's done the right way, maybe you won't have to repeat everything. It won't be as big of inconvenience. But what I'm asking about is prejudice. How will it prejudice the right? When your client went in to try to get a preliminary injunction, I would assume when that was first filed, there was no expectation that this is going to be the trial. Somehow it morphed into the trial. So I'm just trying to see what prejudice would be to let's just do it the right way.
Well, I mean, you're suggesting, Your Honor, that these parties should pay for another 3 or 4 day trial on the same issue.
But that's the nature of the beast, isn't it? When you file a preliminary injunction, usually you have a preliminary injunction hearing in which the movement has the burden. Then that's ruled on one way or the other. It may even come up on appeal. It does sometimes. Then it goes back for trial in which the plaintiffs have the burden. That's just the nature of the beast. So it seems like all I'm suggesting is that we follow the rules of Kansas civil procedure.
Well, but when the parties consented that this was going to be a trial on the merits.
But did they consent? Is there anything in the record that says they consent? I mean, I understand your argument, and maybe they did informally. But we're a court of record. Is there anything in the record that said that they consented? If there is, show it to me, and then I agree. But I just don't see it in the record.
Well, what I think is missing here is nobody. Mr. Booth has not come forward with anything to the contrary that that anybody disagrees that the trial counsel disagrees that occurred. I mean. I suppose we could go back to Judge Mahoney and have him, enter that on the record. But that was the agreement, and the parties tried this case over 3 days with all the evidence, with the understanding that at the end of the day, consenting to this being a final, being the trial on all of the claims in the case.
But the
So-
hearing that was conducted, Ms. Gibson, was your client presenting her evidence and Dave and Emily responding to that evidence. Isn't it only fair that Dave and Emily should be given an opportunity, if we're going to determine ownership, to present their evidence as it relates to them and not just responsive evidence?
They did present their evidence, and that's why Mr. Ong consented to Judge Mahoney entering a final judgment on all of the claims in the case, because he had no further evidence to produce. There was evidence of the costs and the money that Dave and Emily paid. That the agreement was for Dave and Emily to provide this guardian home. Part of that agreement is, as the pet owners or the pet care, the pet home, that they would pay for all of the costs associated with pet care, vet bills, food. And Emily testified it cost $200 a month to feed Oscar. None of that was disputed. The flip side of that is Betsy was to provide all of the medical care and costs and expenses related to showing and breeding Oscar, which is what they did. There was no dispute as to that. So,
But isn't there a dispute of fact between whether this was a guardian home versus an ownership home, a co-ownership home?
there was, and that was resolved by Judge Mahoney.
Well, but not at
No
trial.
uncertain terms.
Okay, and also, if we're going to go down that road, don't we also hold Betsy to when she said on the record that the agreement was when Oscar's show career was over, he would be returned to Emily and Dave as their permanent pet on the record?
Yeah, no, that was absolutely Your Honor, that was absolutely the agreement going in October of 2017.
So why wouldn't that still be binding?
Well, because Judge Mahoney found that, and we argued this in the trial briefs, and we argued this at trial. Judge Mahoney found that when Dave and his friend went to Hampton, Virginia, and snatched Oscar without telling Betsy and without telling Sean Imler, who was her handler, out of the middle of the dog show, without telling them, that they breached the contract, and Betsy was then relieved of her further obligation to perform. And that's laid out in the memorandum decision.
So we're picking and choosing what parts of the oral contract that we enforce?
Well, that's basic contract law in Kansas.
Well, there could be damages. There could be all kinds of things.
Well, the breach of contract occurred as against Betsy. So, and
right, she could have sought damages for the fact that he, if it was improper, that he improperly took Oscar from the show. I just don't understand how that modifies, and we just disregard one section of the contract. But maybe if it was a written contract, it'd be fine, because there might be a severability clause. As far as I know, there is no severability clause in this oral contract.
No, I'm not articulating this. First,
well, it sounds like it's punishment. I think you are. You're saying that because he was a bad boy and took this dog from the dog show, we're not going to require her to perform the rest of the contract.
No, she was relieved from her further performance based on him being the first to materially breach, and that's the way in which he breached the contract. And then he kept Betsy from her ability to show him further, breed him further, after October 2019, when he snatched Oscar from the dog show. Keep in mind, Oscar was a number 4 Connie Corso in the country at that point in time, because he'd been accumulating points. So he was eligible to go to the Westminster Dog Show.
So there may have been damages. And I mean, did anybody seek damages in this case?
Yep, Betsy did.
Was that tried?
It was. Yes, we put on evidence of that, put on the evidence of his value, but the judge in his memorandum decision declined to award Betsy damages for her breach of contract.
And I don't know if you were there, if you heard this when I was asking Mr. Ruth, I'm trying to understand about the American Kennel Club documents. There is a document evidently that was presented that shows them as co-owners. Is that correct?
That's correct. And
was there an application filed by Betsy asking the American Kennel Club to do that?
I presume that she filled out some kind of form that did that.
Well, usually you do, and she's a breeder, correct?
She is.
Okay. And so she submits a form to the American Kennel Club purporting that they are co-owners Wouldn't that be a writing? A document that we could interpret on its face?
That
We
is
usually
not-
interpret writings on their or documents on their face,
yeah.
plain language.
Yes, and there is this is just it's just an American Kennel Club.
Isn't that
Registration.
the
No.
entire registration so she can go to these dog shows?
It is, but I and I don't mean to use to minimize.
I mean,
that,
this
but
is a
there are-
significant document for a full-bred dog that's going to be shown.
It is, and let me make a couple points. Number one,
Okay.
there's a difference in the way that the registration was treated with Grayson and the way the registration was treated with Oscar, which I'll go back to. But first of all, all of these things were in evidence. All of these things are indicia of ownership. All of these things were considered by Judge Mahoney, and he decided that Betsy still had sole ownership of Oscar. Now, the AKC registration is not the end all and be all of ownership. Nothing, and Kansas law is unclear, as both parties have briefed in the briefing. It is not clear what dictates ownership. It can be who pays for the bills. It can be who has registration. All of these things play into ownership. Who possesses, who holds, who purchased the dog, who didn't purchase the dog. There was no sale price for Oscar. They didn't pay for Oscar. So all of those things were factored in. Nothing is a definitive saying that the AKC registration doesn't mean one or the other is the owner.
Why isn't that a document that a court can interpret on its face?
Well,
Just like any other legal writing.
It is it is a document you can look at. It's
And
not
on its why would that not be the document? Doesn't it say that they are co-owners? Now, not all three, but Betsy and Dave.
Well, I think the oral argument the oral agreement that was made dictates who is the owner. Betsy was the breeder. Betsy never transferred ownership and this was the testimony, never transferred ownership to Dave and Emily. That was a delayed transfer, and it would occur at the time that he was retired, at which time they would become the permanent pet home. They were just the guardians in the interim. Betsy's testimony was that she put Dave on here and identified him as an owner out of convenience because her husband Toby was getting ready to die, and she needed somebody else on there. So if something happened at one of these shows, there was somebody to call. That's the testimony, and that's what Judge Mahoney believed. So I do want to give you another case that says that there's nothing in Kansas or the 10th Circuit that addresses directly the impact that an AKC registration has on ownership. None of the cases that Mr. Booth cite say that it is anything more than an indicia of ownership that can be rebutted. So, but this case I think is important. And it's not cited in my brief. It's Boatwright versus Buford, 154 Pacific 3rd, 1184. Can App 2007, and it involves an argument that a partner of a deceased corporation, or partner in a corporation, was trying to get ownership of some racing greyhounds, and she argued that she was the owner because she was listed on their registration certificate, and the court found that did not dictate ownership in that case because the corporation had paid for the greyhounds and taken care of them and those kinds of things. So that's just, the AKC registration is just an indicia, and it was of ownership, and it was rejected by the court here. So, and all of that.
It wouldn't be an admission against interest?
No, well, there's nothing that says it is a presumption of ownership. There's no cases that say that it is anything other than a registration with the American.
So let's follow what you just said, that Betsy put this on here in case she were to die because her husband was ill. So let's say she and her husband both died. So that would Dave not have any rights under that AKC document? Is that what you're saying? So it really was a worthless process to do.
I'm not saying that. I don't think that this document gives him the ownership right versus their.
Well, not versus, but co-owners. It looks to me like on that document on its face, they're co-owners, which would connote joint decision-making.
Yeah, no, what I'm saying is that this doesn't dictate that they are owners or not owners. I think in that circumstance, Oscar, the contract would have been, the oral agreement between the parties would have been, couldn't be performed any further with Betsy showing and breeding Oscar. So he would be immediately retired to them as their permanent pet home and as the owners. If Betsy predeceased Oscar.
Ms. Gibson, your time has lapsed, but I know we've asked you a lot of questions. If you'd like to take a couple moments just to wrap up your main point.
Well, I guess the last point that I do want to make is that there in the briefing, and I don't, Mr. Booth hasn't really argued this, but there was a lot of vilifying of Betsy and criticizing her commercial use of the dogs. I think it's important, and it's a little bit lost in some of the briefing, that Betsy testified that these dogs, that's to her, they were also working show dogs, and she invested a lot of time, effort, and money in training these dogs, loving them, and so that, just on that note, it's not, this isn't a case about who loves the dog more. It's a case about what oral agreement was made and who has ownership of Oscar. Thank you, Your Honor.
Yeah.
Thank you.
Mr. Booth, you have 5 minutes rebuttal.
Thank you, Your Honor. I think where I want to start off is this idea of the breach. The comment was made that David's actions to go and get Oscar from the dog show somehow prevented Betsy from showing the dog or breeding the dog any further. My counter to that first is the fact that throughout the testimony and even at the very conclusion of wrap-up questions by the judge, both Emily and Dave were adamant that they were willing to continue on with breeding and leaving Oscar intact, and did significant steps to make sure that was possible, including a secondary spaying of Grayson in order to have Oscar stay intact. That they were also willing to cooperate with further showing. Dave went as a co-owner and retrieved Oscar because he was concerned over his health. And that was a condition that had repeated itself with dramatic loss of weight and problems, and the record talks of earlier times in which that happened. To Judge Brunn's question about the relevance of a document, I think it is helpful that in volume 1, page 107, when you look at the Kennel Club, at least for some reason, the Kennel Club believed that the two, Betsy and David, are owners. That is exactly what that certificate says. I, in the reply brief, talked about how other states have handled some of these questions about indicia of ownership of dogs. And if you go down that list, it includes things like the continuity of care. That goes to Dave and Emily. Oscar lived with them exclusively throughout this period of time. Even at one point when Betsy did have some contact and this continued alleged deep relationship with Oscar, the training went to third parties, the showing went to third parties. Betsy moves into the house, but was only there from March or so of March 15th and that's in David Emily's house. She had an apartment outside.
Mr. Could I interrupt you for just a moment?
Of course. Your
Okay,
questions are more important than my thoughts.
The ownership, we'll call it that, or the possession of Oscar came to Dave and Emily in October of 2017, on or about October 2nd, correct?
Yes.
And things went really far south in late 2019. Is that correct? Okay,
2 years
so
later.
help me understand what 2018 looked like, because my understanding from the record is that the showing opportunities were sporadic in 2018. So help me understand what 2018 looked like for Oscar.
This is my understanding. were not only sporadic, but they were also local. Meaning that Oscar would go to various local shows. Dave and Emily would have their dog that they'd often participate in the showing. Local trainers, Mr. Chatterson, and showed the dog that Oscar would be away for just episodic periods of time. It isn't until you get to this further time, and it goes back to the question of a contract being able to perform within 1 year. Oscar's matured by the time you get up into the 2019s. He is showing and doing very well early, and getting points in these various shows, but it's all shorter periods of time away, not necessarily longer periods of interruption for training. And whenever Oscar was outside of David and Emily's control, it wasn't that he went to Betsy, he went to somebody local for just some basic training. And there are stories within the facts that talk about, for example, when Oscar ate a toy in Mr. Chesterton's care and David and Emily paid for the surgery, those sorts of things came in and out. But the pattern of behavior was very consistent to when Oscar went home, that was David and Emily. When Oscar was away, it was for these periods of showing. Does that answer your question, Your Honor?
It does. Thank you very much. You have about 30 seconds remaining. I'm sorry.
I can't help but close, but to think and remember the condition that Oscar is suffering from at this point, and that is that dogs love, dogs grieve, and they're there. There is a emotional component, and it isn't necessarily under the law and isn't necessarily at the throw of justice that puts us worried about which human loves Oscar more, but whether the best interests of all are in consideration. And one of those interests has to be to recognize the desperate pain that Oscar is in, and for him to have a fair chance for Dave and Emily to lay out their case and show the intimate relationship of one of their family members and how vitally that is important to them, and they cannot rest until that happens. Thank you.
Thank you. And thank you both for your arguments. We will take the matter under advisement and get an opinion out to you as soon as we can.